Tell me if you've heard this before. Americans love to sue. That's what the world thinks. In fact, that's even what Americans think about themselves. But is it true? Popular conceptions of America would have you believe that suing somebody is treated lightly. And certainly there's a sense that we, as Americans, are quick to threaten a lawsuit if we feel that we've been treated unjustly. Well, I'm here to tell you that American litigiousness might actually be a good thing. See, litigation is a weapon. Americans use this weapon to fight back against resource-rich defendants, from small businesses to multi-billion-dollar megacorporations. And in a country that's weak on regulation, lawsuits provide ample opportunity to sculpt public and private behavior. Let me explain by comparison. Consider Germany. In Germany, legal outcomes are exhaustively coded into law. These codes are so detailed that a plaintiff can often predict how much the payout's going to be if they win their case. And in many cases, the plaintiff's going to get paid a lot less than their actual damages. This works for the Germans because they have detailed regulations and protections too, so the behavior of a business is under strict scrutiny at all times, and it's subject to a broader set of rules. In other words, the bad behavior of resource-rich defendants is thoroughly pre-regulated. Now consider the United States. The USA prides itself on being a place where businesses and wealthy individuals thrive, and for good reason. As a general rule, American businesses are able to navigate much looser regulatory frameworks. So by default, the bad behavior of resource-rich defendants is not thoroughly pre-regulated. And that is where litigation comes in. Instead of exhaustively delineating all possible outcomes, American lawmakers encourage citizens to use litigation to assert their rights. American law enshrines broader duties and principles, like the duty of care associated with negligence. When these broader duties are violated, an actionable claim may develop. This can make it a bit easier for a plaintiff to show that they have a case. So, when an injured American sues a tool manufacturer for designing a dangerous lawnmower, that's meant to serve as a regulatory mechanism of sorts. In Germany, the manufacturer would have likely been forced to undergo a more stringent safety and testing process. In America, the manufacturer has to pay for their mistakes in a lawsuit with their injured customers, and that lawsuit's going to be really expensive for the business. The American way might lead to more injuries overall, but it also creates a much more dynamic regulatory environment. That being said, yes, big issues do slip through the cracks. The American system has also fostered a landscape of innovation and entrepreneurship that has outpaced the rest of the world for the last 100 years. Still don't believe me? Well, check this out. Those who propagate the myth that Americans are unfairly or excessively litigious tend to be companies who want to avoid being power checked by litigation. Take McDonald's. In the 1990s, a famous personal injury case captured public attention, the McDonald's hot coffee trial. In that case, the plaintiff had ordered a coffee at the drive-thru. The coffee wasn't just hot, it was scalding hot. And when it spilled on the plaintiff, she suffered severe third-degree burns. Her life was altered forever by the injuries. Naturally, she sued McDonald's for damages. Her claim was fair. 1, there was no warning label regarding the scalding heat, and 2, the coffee had been heated up to a ridiculous degree. At a drive-thru, one expects that liquids and foods might spill in the person's car due to movement. A multi-billion-dollar global megacorporation like McDonald's should exercise some responsibility by setting and enforcing guidelines for food service so that a small spill of coffee doesn't result in life-altering grim injuries. Seems simple enough, right? Nope. McDonald's spent millions funding a media campaign to paint the hot coffee plaintiff as a litigious, money-grubbing individual out to get paid what she didn't deserve. McDonald's assailed the American system as excessively litigious, and this perception was bought, hook, line, and sinker by the American people. And yet Americans, and people globally, continue to haphazardly blame American litigiousness as a problem, when in reality, companies want you to believe that. They want you to think that you're being greedy if you sue. And of course they want you to think that. They're trying to spend the least money possible on defending against legitimate claims. Something many people don't realize is that the American legal system is adversarial. I know, it sounds bad, but there's some decent reasoning behind this choice. In a non-adversarial system, like, say, the German system, courts are deeply involved in fact-finding, and they work with the parties to come to an agreement as to the outcome. This collaborative methodology can lead to less hostility over the course of the dispute, but it often results in individuals getting less than they deserve. In an adversarial system, the plaintiff and defendant go head to head. This leads to a more hostile process, yes, but it also means that your argument will actually be heard. Adversarial systems are associated with a greater degree of freedom, they protect the rights of individuals, and they avoid bias. So there you go. American litigiousness isn't exactly what you might think. Thoughts? Leave a comment below.